Okay, we are all set.
Ted, you're on mute. You're muted, Ted.
Sorry about that. Good evening, ladies and gentlemen. Welcome to a regularly scheduled meeting of the Zoning Commission, City of Danbury, March 22nd, 2022. Let the record show we'll begin the roll call at 7:35 p.m. Commissioner Coelho.
Here.
Commissioner David. Commissioner David is here. He's on mute now. Commissioner Fay.
Here.
Commissioner Hawley.
Here.
Commissioner Hylinski is absent. Commissioner Jowdy.
I'm here.
Commissioner Malillo is here. Commissioner Rea is absent. Commissioner Bennett is absent. Commissioner Duran is absent. And Commissioner Mejia is here.
I'm here.
Welcome.
Thank you.
The next regular meeting is scheduled for April 12th, 2022. We can all stand for the Pledge of Allegiance. I pledge allegiance to the flag
of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with justice for all. Amen.
Thank you. Let me just read the Zoom instructions. This meeting of the Danbury Zoning Commission is being held on Zoom as a virtual meeting. Even though this meeting is a virtual meeting, members of the public and interested parties continue to have the opportunity to participate in the meeting in a couple of different ways. You can participate via Zoom and see the audio and video, or you can call in by phone and participate via audio only. Please be aware that we may have to mute your microphone or telephone to avoid an echo or some other background noise. This is also being streamed live via YouTube. Instructions on how to participate in the meeting appear on the City of Danbury's website, and all of the documents and materials that apply to the matters to be discussed during this meeting, including the agenda, are also available on the City of Danbury website. As always, if you have any questions, please contact the City of Danbury Planning and Zoning Department. As a reminder, the entire meeting will be posted on and can be seen on the City of Danbury website. We will follow the posted agenda as per standard practice. If prior to the meeting, any questions or comments on agenda items were submitted via email to Sharon Calitro, those comments will be read during the appropriate portion of the meeting. Finally, please remember that technology glitches sometimes do occur. Please be patient if that happens.
Mr. Chairman, can I just interrupt for 1 second before we get going? I just wanted to
Yes.
introduce everybody. This Allie Smith is on the call. Allie is a planning intern. She's been with us for, wow, since the fall, but had previously been in my department a year or so ago, and she's finishing up her master's degree. And so if you haven't met her, say hello, and she's no stranger.
Hey, Allie.
Hi, everyone.
Hello.
Thanks for having me.
Welcome.
Okay,
Thanks for all
thank
your
you,
hard
Mr.
work.
Chairman.
Absolutely, Ms. Calitro. Let's see, acceptance of the minutes, March 8th, 2022. Everyone received it in their packet, hopefully reviewed. Anyone wishing to make a motion to accept these minutes of March 8th, 2022?
I'll make a motion.
Okay.
Thank you. Motion to accept the minutes of March 8th, 2022 by Commissioner Fay. Is there a second?
I'll second.
Second by Mr. Coelho. Any discussion? All those in favor signify by saying aye.
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 Opposed? Not hearing any opposition. The minutes have been accepted unanimously. There are no public hearings this evening. We don't have any continuation of a public hearing. We do, however, have under old business, let me get this out of the way. Old business for discussion of possible action is a petition of the City of Danbury by Sharon B. Calitro, Planning Director, to amend Section 10C4A2 of the zoning regulations in parentheses amendment pursuant to Public Act 21-29, amend language and additional requirements for approval of special exceptions and special permits relative to use of the word character. Note, amendments to section 3C and 10B2 included in this petition were already approved on January 25th, 2022. Commission members, is there anyone willing to make a motion so we can have some discussion? Anyone want to move this to a motion for discussion purposes? I think today is the last day. We got an extension. Mr. John, I'll agree with you in a second. We got an extension from the petitioner, the city of Danbury, to extend it to tonight, the 22nd. Thank you for that extension. Mr. Jody, do you want to make a motion?
I will make a motion to accept this for discussion.
Mr. Jody's making a motion to approve this petition for discussion purposes. Is there a second?
Second.
Second by Mr. Hawley. Any discussion? All those in favor signify by saying aye.
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 Those opposed? So let's get some comments. Mr. Malillo, is that your hand raised?
Yes, the point of order question. The vote that you just called, was that, you called for a vote on a motion? Was that a motion to discuss? Okay, so that was not a motion. That was not a motion. That was not a motion for the petition then.
Not a motion for the petition.
Okay, I would like to make sure the record reflects that the motion is not on the petition, it is to discuss only.
That's correct.
Thank you.
Absolutely. Commission members, why don't we see who wants to?
What did you just say? Wait, I didn't get what Rob said.
No, Rob wanted to make sure that there was a motion to discuss this petition.
Okay,
And not
okay.
on the motion itself.
Okay, thank
All
you.
right. So commission members, we heard the petition as presented. We had some discussion last time. And last time we had Corporation Counsel come and give a presentation as well, or his opinion, I should say, 5 or 6 page opinion on this. I know this is a tricky circumstance that we've been put in by the state. We've been getting a lot of these issues coming down to us by the state. I think the good news is we've been able to opt out of a lot of these. This one here, we cannot. So we have to take some action on it. So tonight we have to approve the third leg of that petition or deny it. With that said, does anybody want to step forward and tell us your feelings on this? And then we can discuss it further. If we don't get any discussion on it, I'm going to have somebody make a motion to either accept it or deny the petition. So we can, I guess, discuss at that time. Commissioner Fay.
Can I discuss it now?
Yeah, absolutely.
I mean, it seems as though our hands are tied in terms of what we need to do. So it's sort of pro forma that we're even given the option to take this vote because it's coming down from Hartford that this is what needs to happen, if I understand it correctly. So it's just substituting out the word character for, I don't know, some other synonym that I don't know why it will resonate differently legally, but that's how it appears, as though it's sort of artificial, but that's the position that this commission is in.
That's the way I see it. The good news is we have been explained to by Corporation Counsel that there are other ways to get our point across without using that word character. But yeah, I mean, I'm not that thrilled when we get these things handed to us from Hartford, as along with many of us here, and I'm sure other boards and commissions, not only in Danbury, but throughout the state. But they're on a run up there, and we bear the brunt of it. So we have to take some action on it. And I think our Ms. Kalitra did a good job in thinking what she should do to help us along with this and to find solutions. And Corporation Counsel also gave their opinion on it and gave us some ideas on how to handle it and accepting or denying petitions on a going forward basis without the use of the word character. You agree with that, Ms. Fay? That about sum up what, I mean, am I sort of on the same
I do, yeah,
conversation with you?
I have the same understanding.
Yeah. Anyone else have anything?
feelings.
Thank you. Anybody else want to contribute any thoughts to this? Okay, so it doesn't look like anybody wants to, has anything to discuss on this. So I think what we would be looking for at this point would be a motion to either accept with reasons or deny this petition. So is anyone willing to make a motion on this petition? Oh, in fact, Attorney Casagrande, can I confirm with you that you checked to see that if we don't approve this by its expiration, it's not an automatic approval?
That's correct, Mr. Chairman.
Okay. So if it expires this evening with no action, it's dead, just like a motion to deny?
Well, if you don't take any action on it, it doesn't die, doesn't deny unless it's either approved or denied or it's withdrawn. So if you take no action on it tonight, the petition is still pending.
Well, no, the petition expires this evening, no?
No, the petitioner's consent to an extension expires this evening.
Right, okay. Got it.
But if we don't take any action on it, the law still applies to our zoning commission and our zoning regulations, regardless of whether they conform with what Hartford sent down, right?
That's correct, Commissioner Fay.
What was that? Can you repeat that again? Someone had their mic off, the mute off.
It's just that the law on review by Superior Court or on appeal is going to be the law, in that they're going to look at this word character possibly in a discriminatory light, regardless of whether our regulations conform with what Hartford has done. So I mean, it's the same result either way. It's probably better to have our regulations reflect the current legislation, is what the petition is asking.
Thank you. So are you willing to make a motion to that effect?
Yes, I will make a motion. I will make a motion to accept the petition. And my reason is just that it makes more sense for our regulations to conform with the current legislation in the use of the word character throughout our regulations.
Mr. Chairman, can I just ask for a clarification? You mean,
Yes.
Ms. Fay, you're making a motion to approve the petition, correct?
Yes. Oh, I said accept.
Yeah.
I mean approve. Yes, I do.
Thank you.
Thank you.
Thank you both. Thank you both. There's a motion made by Commissioner Fay with the reasons. Is there a second? There is a second. Mr. Hawley, unmute and just say it, please. I saw your hand.
I second the motion.
Thank you very much. Second by Commissioner Hawley. Any discussion on the motion? Any discussion, commission members? Commissioner Melillo, please.
Yeah, I just want to go on record that I'm going to vote no on this petition and I realize I may be the only one, but on the principle of not being told what Hartford dictates us to do, and I do feel as though we could define the word character as was stated earlier on the record, and then keep it in our regs. So I would much rather have seen us do the option to define the word character rather than just strike it from the existing regs.
Thank you very much, Commissioner Melillo. Any other discussion, commission members? Mr. Coelho, your box just lit. Is that you?
I have, yes, is that okay? Just a question.
Sure, absolutely.
So if the petitioner, if we vote on it tonight, one way or the other, and if 3 months down the road, the petitioner decides to want to revise it, they still have that opportunity to do that or put a new petition in with some different language. Let's say there's an evolution or a change in that language that we don't even know about at this present moment. Even Corporation Counsel says, oh, there's been a change, etc. They still have that opportunity to put another petition in that may give us the opportunity to vote yes or no and change the word characteristic or anything else, right?
I would say, yeah, but I'll have Ms. Calitro address that.
Thank you, Mr. Chair. Yes, it can always come back to you on behalf of the city, or if you found something else, the commission can propose an amendment on its own.
Okay.
Good question, Mr. Coelho. Thank you, Ms. Calitro. Any other discussion? Any other discussion? Any other discussion? Any other discussion? So let's go take a vote. A yes is yes to approve the petition. A no is no.
Mr. Chairman, before you do that, can I just,
Sure.
for the record, Olga, I know that you weren't there in January. Can you just put that on the record so she's not eligible to vote?
Okay, yes.
Yeah, thank you.
Eligible, none of the alternates are eligible to vote. Okay, a yes is yes, a no is no. Ms. Fay,
Yes.
Mr. Hawley,
Yes.
Mr. Coelho,
Yes.
Mr. David,
Yes.
Mr. Jowdy. He's raising his hand, yes. I'd rather hear it, though. He's saying yes. Mr. Melillo, Commissioner Melillo.
No.
And I will vote yes. 1, 2, 3, 4, 5, 6, 7. 1, 2, 3, 4, 5, 6, 7. 6-1. This is approved. Thank you, commission members. We don't have.
Chairman,
Yes, Commissioner Melillo.
there's a lot of noise here where I'm at.
Commissioner
So
Melillo.
I'm gonna go
please.
ahead the meeting and I'll watch. I'm gonna go ahead and leave the meeting to the noise around me, and I'm gonna watch the workshop at a later date online on the video.
Thank you very much. Let the record show that at 7:51, Commissioner Melillo has left the meeting. Number 8, under new business, there is none. Number 9, under correspondence, there is none. We do have one issue of their other matters, and it's the workshop session regarding zoning commission procedures and statutory requirements. And here this evening, we have Attorney Dan Casagrande and Attorney Robin Edwards. And for some of the commission members that have been here before, a lot of it we've heard. There'll probably be some new case law or some new additions to it, but it's always good to hear it over and over and over again. And the new members, this is always very interesting and enlightening, very, very interesting. And we do appreciate Attorney Edwards and Attorney Casagrande for doing this. Thank you very much. So which one's going to start?
Joanne, can you share the screen? Because I'm going to run the PowerPoint for them.
Thank you, Mr. Chairman. I will be starting the presentation this morning, this evening, excuse me.
Thank you.
Feels like this morning still.
Yes.
And we'll have a slide presentation and we will provide you with the members with the outline later. And Sharon's going to share the screen and she will advance the slides as we go through the outline.
That's great. Thank you very much.
Oh, you're welcome. Thank you. So thank you.
Everybody can see this? We're good? Okay.
Great. Thank you.
Got it.
So what we'll do is we will go through the outline this evening. I will do the first portion of the outline. Attorney Casagrande will finish up with the second portion. And this is just a general overview of zoning and the different standards and things that apply. And we ask if you have any questions that you save your questions until the end so we can get through our presentation, and we'll be happy to answer any questions that you might have at the conclusion of our presentation.
Thank you.
You're welcome. So zoning commissions, I will first start out with just briefly discussing the powers and duties. As we all know, the zoning commission is a creature of statute. Connecticut General Statute Section 8-1 authorizes municipalities to create local zoning commissions. We derive our powers from the state. The function of the zoning commission is to act in the public interest in zoning the municipality and administering the zoning regulations. In Danbury, we've created our zoning commission through our charter. That is memorialized in Section 2-2 capital A of our charter. The members are elected. We have 9 regular members and 3 alternates. We need a quorum of 5 members to conduct business. The functions of the zoning commission are both legislative and administrative. In your legislative capacity, you act to amend the regulations, you adopt and amend the regulations, and you also adopt and amend any changes to the zoning map. Our regulations can be amended or modified whenever time and experience reasonably indicate a need for a revision to our regulations. As members of the zoning commission, the commission has broad discretion over the content of its regulations. However, the regulations must promote public welfare and they must be administered and adopted in a reasonable fashion. In your administrative capacity, you hear both applications for special permits and motor vehicle dealers and repairers licenses. In the special permit instance, you hear and decide special permits for applications involving restaurants, liquor stores, cafes, taverns, grocery stores, package stores, and breweries and distilleries to the extent that the sale of alcoholic beverages is involved. In looking at the motor vehicle dealers and repairers licenses, the commission members act as agents for the state. The commission determines if a use is permitted in the district, and the commission considers the suitability of the location and whether it will imperil public safety if one of those particular uses is located where they propose to be located by their application. Prior to considering this, the planning department must either approve or waive a site plan before this special permit application can be filed. The zoning and planning process, we will look at an overview of the legislative function now. I will just touch briefly on the history of zoning. Connecticut was one of the first states to enact statutes regulating land use. The first land use laws were enacted around World War I. Zoning came about in the late 1800s to early 1900s. We experienced growth in our urban areas. Along with growth came what we experience today: congestion, traffic. You had incompatible uses at the time. You had industrial and commercial uses being located in residential neighborhoods and vice versa. So the first zoning ordinances were actually nuisance abatement ordinances, which gradually evolved into plans for the creation of the overall development of municipalities into districts in the furtherance of public interest. Planning itself was not widely used until about 1947. I'll touch briefly on probably a seminal zoning case that you all have heard of, where the concept of Euclidean zoning comes from, and that's the Village of Euclid versus Ambler Realty Company. And that's the United States Supreme Court case from 1926, actually. And in that situation, the Supreme Court of the United States upheld the right of towns and cities to adopt regulations dividing a municipality into several districts and segregating the different uses, residential, business, and industrial uses, apart from each other. And this was the beginning of zoning, and the court held in this situation, they considered that the regulations implied in that fashion do not violate a property owner's due process rights because it's in furtherance of the police power. Something we touch on all the time. Is it in the interest of public health and safety? A balancing, if you will, of the interests. And in this case, the court held there was no taking of private property, that that this type of zoning was proper. And that's really the basis of zoning today. It upheld zoning as a legitimate police power. And it formed the basis, as I mentioned, for dividing land in municipalities into districts and restricting the types of uses allowed in each district. Kind of where the concept of geometric mapping of districts started. So in Connecticut, the legislature has set forth the powers for zoning in section 8-2. That's where it's a source of police power. It tells you what you can and cannot do as members of the commission. It's always a good idea to take a look at 8-2. Of course, it's adopted. It's amended from time to time. We have had amendments to it most recently. And it's a good idea. It's kind of like where everything is. It's quite dense and lengthy statute, but it's something that we always find ourselves going back to all the time. And the key language in 8-2 reminds us of the overriding planning purposes of our zoning regulations. And I'm just going to hit briefly on some of the high points. As I mentioned, it's packed with information. One of the high points is that the zoning commission can divide the municipality into districts of such number, shape, and area as may be best suited to carry out the purposes of Chapter 124, which is the chapter that addresses zoning in our statutes. And within the districts, it can regulate specifically the erection, construction, reconstruction, alteration, or use of buildings or structures, and the use of land. So the overall goal is to have a plan that works for the municipality. Zoning regulations shall be made with reasonable considerations as to the character of the district and its peculiar suitability for particular uses, and with a view to conserving the value of buildings and encouraging the most appropriate use of land throughout the municipality. The regulations must be uniform for each class or type of buildings, structures, or use of land throughout each district, but the regulations in one district may differ from those in another district. That's the concept of uniformity. The regulations may provide that certain classes or kinds of buildings, structures, or uses of land are permitted only after obtaining a special permit or a special exception from, in our case, the zoning commission, subject to standards set forth in the regulations and conditions necessary to protect the public health, safety, convenience, and property values. So the regulations have standards to protect the public health, safety, convenience, and property values. Section 10C4 in our case that we look at often in our regulations. The regulations have to be made in accordance with a comprehensive plan. And in adopting the regulations, the commission shall consider the plan of conservation and development. So the comprehensive plan is our zoning regulations and our map. That's really a simple way to say what the comprehensive plan is. And in adopting that, we have to consider, or the commission has to consider the plan of conservation and development, which is ultimately adopted by the Planning Commission under Section 8-23. Our plan now is in the process of being updated and will be updated at some time in the near future. Sharon and others are very busy working on that right now. I'm going to touch on some core zoning principles. Something I just touched on recently is the principle of uniformity. The regulations must be uniform as to the district for each class and type of use. So you can have similar but different zones, and they can have different requirements, but they have to be uniform in the entire district. There is no contract zoning. You cannot condition a zone change. That is generally not allowed because there's no statutory power to allow a zoning commission to condition a zone change on other actions or events. Police power. The power to zone is not unlimited. It must be, the regulations have to reasonably relate to the police purposes of Section 8-2, and it will be declared actually a taking if they're so restrictive as to prevent a property owner of the loss of all reasonable use of his or her property. So it's a balancing test. Police powers allow for legislation of property, but it cannot be uncontrolled because the uncontrolled use would be, or the uncontrolled regulation would be harmful to private property rights. So it's a kind of a fact-intensive inquiry. Vagueness regulations, if they are vague, there's a potential that regulations could be declared unconstitutional. There has to be a standard that applies to all and that can be understood and that can be applied. The zoning regulations are strictly construed because zoning is a derogation of common law. There's a limitation on private property rights. Therefore, the regulations are interpreted and narrowly construed in favor of the property owner. Our zoning regulations in Danbury are permissive. What is not expressly allowed is prohibited. The comprehensive plan. The comprehensive plan, as I mentioned, consists of the zoning regulations and the map, which divides the municipality into districts. And all zoning regulations and boundaries have to be consistent with a comprehensive plan. The relationship of zoning to planning, and I'll just touch briefly again on the plan of conservation and development. So good planning is critical to good zoning. They work, the concepts or principles work hand in hand. The Planning Commission statutorily has to adopt a plan of conservation and development, which we do have. As I mentioned, it's being updated, and it's the overall plan of development for the city. The types of things that are considered in adopting such a plan is what types of uses go where? What is the most desirable density of a population in various districts within the city? What areas should be conserved? What are the goals for the physical and economic development of the city? And as you know, when our zoning regulations are amended, the zoning regulation has to make, commission, excuse me, has to make a finding that the amendment, any such amendment, is consistent with a plan of conservation and development. The plan is a recommendation, but the commission must consider it, as I just mentioned, in adopting or amending regulations and zoning districts. The uses allowed in a zoning district must be compatible with the stated purposes of the district, as found in our regs and in the plan of conservation and development. If that is not the case, then you have an incompatible mix of uses, and that could potentially destroy the integrity of a particular zone, destroying property values, destroying property owners' reasonable expectations. So bad zoning undermines the plan of conservation and development and its goals, which are the furtherance of health, safety, and welfare. And both the Planning Commission and the Zoning Commission have to consider the plan of conservation and development and make express findings on it when considering changes in the regs or the zone boundaries. So in other words, the commissions look at, is the proposed change consistent with a plan of conservation and development? It'll be very exciting to read our new plan when it's adopted and see how things have changed and what is being updated based on the growth that's occurring in our city. Another point just to consider, and this sort of goes in line with what I just said, is zoning is not nuisance abatement. I know I hit on this earlier. Always consider the plan. What is the plan for the city? What is the plan of conservation and development say? Don't zone just to zone out a nuisance or a particular use. Base the zoning on an overall plan that's in the best interest of the entire community. And sort of a way of an example is, just because a proposed use is not a nuisance, it does not mean that it's necessarily appropriate for a particular zone. The example in the outline is a small office building may not be a nuisance to a surrounding residential neighborhood, but that in and of itself may very well be inconsistent with the city's plan of conservation and development. Another principle to consider is the highest and best use concept, which is an appraisal concept. That is not a concept that controls or should control zoning decisions. It's not a principle which furthers the purposes of zoning, nor is the maximum possible enrichment of any particular landowner. The purpose of zoning is to control the use of the land and to promote the public interest. In other words, look at the best interests of the community as a whole. I'll touch briefly on spot zoning now. Spot zoning, as you know, is generally described as singling a particular parcel of land out for special treatment in a way that does not further the comprehensive plan. So in order to survive a spot zoning challenge in our courts, any change of zone must be in accord with a comprehensive plan and reasonably relate to the police power purposes set forth in section 8-2 of the Connecticut General Statutes. If that's the case, then modern cases today generally uphold the zone change. Spot zoning is sort of becoming a more of a concept of the past. So spot zoning is inconsistent with a planning goal of an overall development of a plan in furtherance of the public interest. It requires a very fact-intensive inquiry into the particular situation being considered. Considerations for the commission to think about when amending the regulations or the zoning map is always remember amendments to the regulations to allow a use in a specific zone are effective not only as to the applicant before you, but as to all properties located within that zone. In exercising its legislative judgment, the commission can and should consider the amendment's effect on all properties in the city located in the zoning district that the property before you is in. So a conceptual site plan submitted by an application is exactly that. It's a conceptual site plan. It does not necessarily limit the maximum use of the property, nor does it particularly mean that that's the use that might actually end up there if the zone change is granted. So the commission always should consider the maximum development potential of a site if any change is granted. Voting requirements, the majority of the commission, of the entire commission is required for something to pass. That's 5 votes. There are some situations where 2/3 vote is required. And that is essentially in a situation where a protest petition is filed at or before a hearing. And that would be a petition that's filed by the owners of 20% of the lots included in the change, or lots within 500 feet of the subject property. That requires 6 votes. And there are different agencies that matters are referred to as well, other agencies, and Attorney Casagrande will hit on that later in the outline. And lastly, I'll just hit on, the zoning commission should always consider the consistency of the petition before it with a plan of conservation and development. Look at the plan, read the sections, be familiar with the plan, and then the commission goes on under section 10I3 of our regulations to look at the general criteria, as well as any specific criteria enumerated that pertains to the specific zone or the petition before you. So thank you. Attorney Casagrande will now continue with the remainder of the outline, and we'll be happy to answer any questions at the conclusion.
Thank you, Attorney Edwards. Appreciate it.
You're welcome, Mr. Chairman.
Thank you, Mr. Chairman. Members of the commission. My section, which again, I'm going to do it rather than just come.
Attorney Casagrande, we're having trouble with the mic.
I'm not on mute. Can you hear me?
Yep, we got you now. Yeah.
Can you hear me now?
Yes, we can. Thank you.
All right. Okay. My portion of the outline is going to focus on the so-called administrative process. In other words, what happens after the zoning commission amends the regulations or changes the zoning map. And you might ask, well, why is it important for this commission to understand what happens afterward? And it is important because what happens after you decide to change a zone or adopt a regulation should inform your decision at the outset of whether it makes sense to change the zone or change the regulations. So that's why we thought it'd be important to give a brief overview of that. So the first administrative process that you'll hear discussed by Director Calitro and the planning staff is site plans. What is a site plan? A site plan is a plan, again, it's authorized by Section 8-3 of the general statutes, and it's simply a plan that shows a proposed use on a specific site and shows all the information required by the local regulations for such use to be permitted. And it is required, a site plan is required by our regulations for all permitted and special exception and special permit uses, except for 1 to 3 family dwellings. In a 1 to 3 family dwelling, all you need to do is submit a plot plan that basically shows the setback and the height of the building. But for anything more than that, a site plan is required. The site plan requirements are set forth in Section 10D3 of the regulations, and it's a very detailed list of all the technical requirements that a proposed permitted use must meet in order for the Planning and Zoning Department to approve the site plan. The site plan, if it's just a site plan that's submitted for a use that's permitted as of right in the district, the Planning and Zoning Department is the sole body that reviews and decides whether to approve or deny the site plan. They can approve it, they can modify it to comply with the regulations, or they can deny it. But a site plan can only be modified or denied if it fails to comply with the requirements already set forth in the zoning regs or in the inland wetlands regulations adopted by our Environmental Impact Commission, which is the wetlands agency for the city. In other words, if a use is permitted as of right and it meets the site plan requirements, there is no discretion. The Planning and Zoning Department must approve it. And it must be based on the specific criteria set forth in Section 10D3. Again, it's essentially a technical determination that the staff makes in-house. If a particular use is permitted as of right in the zone, the case law says that a conclusive presumption arises that such a use in general will not adversely affect off-site traffic. In other words, you can't deny a site plan for use that's permitted as of right in the district just because there's some concern that it might have some adverse effects on off-site traffic safety or traffic congestion issues. Now, for on-site traffic issues, Section 10D11AI of the regs allows the department to inquire whether the ingress or egress to the site will adversely impact the normal flow of traffic or normal safe conditions of the roadways. But this language doesn't mean that a site plan can be denied because of off-site traffic volumes and patterns, as I mentioned. So, and just to back up for those of you who are new, the sequence of events when you're trying to get approval to start building a building is you first go for a site plan before the Planning and Zoning Department. Once the site plan is approved, you get a building permit from the building official. That allows you to actually start the construction. Once the building is constructed, the applicant then has to submit an application for a certificate of zoning compliance with the zoning enforcement officer. That's based on the as-built nature of the structure. And then once that's issued, the building department will issue a CO. So it's site plan, zoning permit, certificate of zoning compliance, and then a CO. The next administrative category is special permits and special exceptions. Those terms are essentially interchangeable under Connecticut zoning law. And in Danbury, under our regulations, the zoning commission issues special permits, as Robin said, for restaurants, taverns, and other facilities that serve alcohol. The drafters of the regulations deemed the zoning commission to be the appropriate body because of the perceived municipal-wide effect of the service of alcohol on all residents. For special exceptions, which are also listed in the particular zoning districts in the regulations for each district, you'll see what uses are permitted as of right and what uses are permitted via a special exception. The planning commission determines whether to issue a special exception. So again, what's the difference between a special exception or special permit and a use permitted as of right? A use permitted as of right is one for which the zoning commission has already made the determination in amending the regs that a particular use is appropriate in a particular area. So again, if the site plan submitted for a permitted use as of right is okay, it complies with the technical requirements, it must be approved. In contrast, in a special exception or special permit situation, the reviewing commission has more discretion. It has to determine whether the proposed use in the particular district would be compatible in the district and with the uses permitted in that district as of right. And what you do and what the regulations set out and what 8-2 provides you the Bible for, as Attorney Edwards indicated, is the commission, planning commission in the case of a special exception, zoning commission in the case of a special permit, looks at the proposed use and makes general determinations, discretionary determinations regarding the suitability of the use, its effect on property values, traffic safety, traffic congestion, parking, noise, etc. All those terms you'll find in 8-2, and you'll also find them in our special exception criteria under 10D4. The basic principle of special exception and special permit uses is that the zoning commission has generally determined that they're generally compatible with permitted uses in a district, but because of their specific nature, a school, a hospital, a church in a residential neighborhood, for example, their particular location in the particular neighborhood must be scrutinized because of potential concerns about topography, traffic problems, neighboring uses, etc. A special permit application must be denied if the underlying site plan does not comply with all technical requirements of the regulations. That's the McKenzie case that is often cited, and you'll probably hear it cited by a lot of applicants for special permits and special exceptions. And the theory, the purpose of that rule is that only the Zoning Board of Appeals can vary the regulations on a case-by-case basis. The Planning Commission and the Zoning Commission have no authority to vary the specific requirements of the regulations just because they think it's a project that should go forward. If it doesn't meet even one requirement of the site plan regulations, the commission has no discretion but to deny the application for the special permit or the special exception. A commission may deny a special permit and special exception based on general public health, safety, and welfare standards set forth in the regulation, even if it meets all technical requirements. So the first proposition is if it doesn't meet the technical requirements, it has to be denied. But on the other hand, even if it does meet the technical requirements, the Planning Commission and Zoning Commission has the discretion to deny it if they find that the use does not comport with the general public health, safety, and welfare standards set forth in the regulations. An interesting issue that is going to be decided very soon by our Supreme Court is, can a commission deny a special permit or special exception application based on general standards in the regulations when there's no evidence that the proposed use will have an adverse effect at its particular location in the particular district. The case that's now before the Supreme Court is called Mclaughlin versus Bethel Planning and Zoning Commission. I'm very familiar with it because I argued the case before the Supreme Court in the fall, and we're waiting for a decision. It's kind of an interesting fact pattern. What happened there was that the Planning and Zoning Commission in Bethel, it's one commission. They, at my client's request, they amended the zoning regulations to allow for a crematory as a special permit use in the industrial zone. So my client, in reliance on that, goes out, gets his engineering plans together, hires lawyers, and submits the special permit application literally months after the amendment was adopted. And by the way, the amendment specifically said that the zoning commission finds that a crematory in the industrial district is compatible with the other uses in the industrial zone. So my client goes in and he applies for the special permit application, and lo and behold, the Planning and Zoning Commission denied the special permit application because they turned around and said it wasn't compatible in the district. And my contention in the case is that there was no site-specific inquiry as to the compatibility of the particular use at its particular location. And the argument is, and Judge Fuller in his treatise and other courts have noted that there's a potential for abuse of discretion when a zoning commission says, yes, you can have this use as a special permit in the zone because it's compatible, and then the applicant turns around and expends considerable resources to put together the special permit application, and then the commission turns around and denies it on essentially the same general health, safety, and welfare concerns that didn't give them a problem when they filed for the zoning for the amendment. So we should know about that very soon, and obviously we'll keep you posted. The standards for granting a special permit or a special exception are set forth in 10C4. I'm not going to read all these to you. That basically sets forth the 4 considerations that you have to consider in determining whether to grant a special permit or a special permit or a special exception. You'll note that after 21-29, Public Act 21-29, which you voted on earlier this evening, we're going to have to do some advice to the Planning Commission and the Zoning Commission to make sure that we don't have a special permit or special exception application denied solely because of the quote character of the district, if it's not related to the physical characteristics of the building on the site. But as I said in my opinion letter to you a few weeks ago, our office does not think that the amendment in 21-29 will materially limit your discretion in utilizing the traditional standards for consideration of special exceptions and special permits. Very quickly, there's additional standards for special permits involving alcohol sales, which is within the Zoning Commission's purview. And for those, Section 3F2B through D of the regs requires the Zoning Commission to find that the proximity of the premises or the building will not have a detrimental effect upon adjacent schools, churches, or other places of worship, and it will not have a detrimental effect upon the immediate area after considering the compatibility and impact of the use on the surrounding area, including adjacent residential neighborhoods. The Zoning Commission also has to consider the impact of the use upon traffic congestion and traffic safety. And this proposition that I cite in that bullet paragraph, it actually applies to both special permits and special exceptions. If you're going to deny a special permit or a special exception because of traffic congestion, the record has to show that the increased traffic congestion will be substantially more than the traffic congestion that would be caused by a use permitted as of right. That's the Cambodian Buddhist Society case, which you'll also hear cited by many applicants and their attorneys. And another interesting part of a special permit review by the Zoning Commission is that in a special exception context, the applicant has to submit not only the special exception to the Planning Commission, but also the site plan. So the Planning Commission in that situation approves the site plan as part, or denies the site plan as part of its determination on whether to grant or deny the special exception. For a special permit, the 10C4B3 says that the Planning and Zoning Department either has to approve or waive the site plan for the special permit use before the special permit application may be filed with the Zoning Commission. Again, a little quirk in the differing treatment of special permits and special exceptions. Next, just very briefly touching on the overlapping jurisdiction of land use agencies and notice and referral requirements. Attorney Edwards has already focused on the need to refer proposed zoning regulation amendments and boundary changes to the Planning Commission. I won't burden you by going through all of those requirements, except to note that if the Planning Commission issues a negative recommendation under 8-3A, you can only vote to approve the zoning amendment upon an affirmative vote of 6 out of the 9 members. And again, this is the importance of understanding why it is you need to comply with these requirements. There's case law out there that says that if the Zoning Commission fails to obtain and read the Planning Commission's 8-3 referral report into the hearing record, the adoption of the amendment will be overturned by the court. Somewhat hyper-technical, but that's the law. Notices and referrals to other agencies. Again, I'm not going to burden you by reading the verbiage. Under certain requirements, you have to give certain situations. You have to give notice to the adjoining municipality for projects that are within 500 feet of the boundary of that municipality. You have to give notice to the regional planning agency for changes in zoning regulations or boundaries affecting the use of a zone within 500 feet of the boundary of another municipality within the regional planning agency area. Notice is required to be given by the applicant for projects to water companies if the site of the project is within the watershed of a water company, provided that the water company has filed with the city a map showing the boundaries of the watershed on the land records and with the Zoning Commission, Planning and Zoning Commission, or ZBA. And in the case of wetlands, if an application for a boundary change before your commission involves a site on which there are wetlands or watercourses, the Zoning Commission must consider whether any H-2 factors are implicated by that. What does that mean? It just means you have to look at, okay, if we're going to change the zone or change the use of this property and it has wetlands on it, is that going to implicate public health, safety, and welfare concerns? Additionally, for a special exception or special permit application, if that involves a regulated wetlands activity under the EIC's wetlands regulations, the applicant has to submit the wetlands application to the EIC before or no later than the day that the special permit and special exception application is filed. And in that case, even if you've concluded your public hearing, the commission has to wait for the EIC decision and report on the wetlands application and give it due consideration in making its decision. I want to focus the next couple minutes on protecting the decision and problem issues. In other words, we always have to be mindful, both the commission and the Corporation Counsel's Office, as to how to minimize the chances for successful appeals from your decisions. And so that's why it's important to be cognizant of these problem issues and the decision process. So first is the hearing process itself. And I know Chairman Haddad and Chairman Melillo before him have been very scrupulous about adhering to these requirements, but you have to allow the public to inspect all documents and plans submitted with an application. You have to include all written reports and comments in the hearing record. In other words, log in the exhibits. I know sometimes it's very hard. You get a flurry of exhibits in from many people, but you have to take the time to identify the exhibit, give it a number, give it a letter, read aloud the Planning Commission and Planning Agency reports into the record. You need to identify the speakers. There's a reason why you need to do that, because if there's an appeal and there's just a cold transcript of someone speaking, but the court doesn't know who the speaker was or where they reside or what their interest is, that transcript is not helpful to the court. The next concept is fundamental fairness. All zoning applications and special permit applications are governed by the concept of fundamental fairness. And what that means is you have to provide all interested persons with a fair opportunity to comment, to introduce exhibits, to cross-examine witnesses and cross-examine witnesses through the chair. In other words, you can't just start asking an applicant or someone from the public can't just start asking questions like it's a courtroom. It always has to go through the chair in order to preserve the proper decor. But some commissions incorrectly think that, well, there is no cross-examination allowed. No, there is cross-examination allowed. And it's up to the chairman to make sure that cross-examination occurs in a fair manner that will allow the opponents or proponents to make their points. You have to adopt and adhere to a basic protocol for conducting a hearing. Your commission has adopted Robert's rules as a bylaw. And those rules, and I know Mr. Melillo is a maven on Robert's rules, and which is very helpful to the commission. But those rules, for example, require that all questions be directed through the chair, that people speak clearly and not speak until they're recognized by the chair. In other words, again, how do you create a clean, organized record that will allow our office to best defend the decision in an appeal? You always have to be cognizant, especially in controversial applications, that whatever you decide, it's going to go up to a court, and you want to give counsel the best opportunity to defend the decision based on a clear, organized record that recognizes principles of decorum and civility. Ex parte communications. What are those? That's just communications between any member of a commission and another person outside the hearing record. The bottom line is you need to avoid them. They create a presumption of prejudice in the decision. And what happens is if there's evidence that an applicant or opponents to an application find out that there were emails back and forth between commission members, even among commission members or members of the public, and those communications are not put on the hearing record, what that creates is it makes the decision suspect, and it switches the burden in any court appeal to the commission. Normally the burden is on the unsuccessful applicant in the case of a denial, or an unsuccessful opponent in the case of approval. It's ordinarily their burden to show that the commission acted fairly. When you have ex parte communications, that is reversed. The commission now has the burden to show that the ex parte off the record communication did not affect its decision. So the best practical way to avoid this issue is if you're contacted by anybody outside the decision, you get a phone call, you meet somebody in the grocery store and they want to talk to you, you just have to respectfully decline to discuss the matter. And most conservatively, I suggest that you come back, if the hearing is still open, or even if it's closed, put it on the record that you were contacted and you told this person that you could not discuss the matter with them. Again, you're protecting the record on the appeal. And as I said, even communications among commission members should be avoided. Don't text each other, don't email each other. If you have any question on an application, contact Director Colitro or the staff. Those communications are entirely permissible because the staff is there to provide guidance to you. Receipt of post-hearing evidence. After the hearing closes, the rule in Connecticut is that the commission may not consider any evidence that is submitted or presented after the close of the hearing. If you do that, you're setting yourself up for reversal of your decision. And the basis for the rule, again, it goes back to fundamental fairness. Consideration of any post-hearing evidence denies people due process and fairness because it doesn't allow those people to comment on that evidence during the hearing, so they have a free opportunity to oppose or register their position on it. So bottom line is, if you get anything from the applicant or the public after the close of the hearing, just give it to the staff and note on the record that you have not considered it. Now, there is an exception to this rule against receipt of post-hearing evidence, and that's for receipt of reports from the staff, Sharon, the engineering department, et cetera, and our office too, opinions from the Office of Corporation Counsel, as long as those reports are based on information and evidence that's already in the hearing record. Those reports cannot add new evidence. And there have been many times in my experience representing the commissions in Danbury where that's often a point raised by an appellant that post-hearing reports from the staff or from Corporation Counsel really contained new information in it, and it wasn't based on evidence in the hearing. And so, again, we believe as your counsel that the most prudent course when you're dealing with these kinds of staff issues, especially on controversial applications, try to get all the staff reports in before the hearing closes. This way you just eliminate any potential claim that there was an illegal receipt of evidence after the hearing closed. The role of staff. The planning and zoning department's role is to act, obviously, as your advisor and consultant. It provides you with guidance on technical issues, city policies, precedents, and procedures, as well as historical information on the regs and on particular sites. And it's important for you as commission members, I believe, to understand the different types or the different roles of the staff, which is to give you guidance on applications submitted by private petitioners and representatives of the petitioners. Their role is as advocates to advance their client's cause. A very recent case just a couple of years ago is and I would commend it to you. We can get copies of the decision to you, but it's an excellent case study on the respective powers of the Planning and Zoning Commission and the role of the planning director and her staff in providing professional guidance. And for those of you who've been on the commission, remember this was when ECB Realty applied for a special exception to the Planning Commission to put a convenience store with a drive-through window in the CA80 district. And they went to Director Colitro before they filed the application and told her what they were going to do. And that raised red flags in Director Calitro's mind, because she realized that allowing this kind of drive-through window with a convenience store in the CA80 district is not compatible or consistent with the general prohibition in the CA80 zone of all kinds of fast food restaurants, which have drive-through facilities. So what Sharon Calitro did is she recognized the problem. She submitted a petition to the Zoning Commission to amend the CA80 regulations to basically prohibit any use except for pharmacies and other limited uses. Any use in the CA80 district would be prohibited from offering food and beverages through drive-through windows to people in cars. That amendment passed. The special exception application before the Planning Commission also failed for other reasons relating to traffic. And the applicant sued both the Planning Commission and the Zoning Commission. And one of the central arguments in the appeal was that Sharon Calitro was biased and had an improper motive in recommending what she recommended to the Zoning Commission. In other words, she foresaw the problem and she acted in her best professional capacity. But the applicant characterized it as no, she was biased and she was acting for personal interests. What those personal interests would be, I never really could understand. But the court opinion affirmed both decisions, and it summarily rejected the claim that Sharon Calitro was in any way biased. And I think it's worth reading the excerpt from the opinion. In this case, it's evident that Calitro believed that the subject application was in contravention of what the zoning regulations intended to accomplish with respect to the regulation of development in the CA80 district. Her professional opinion guided her in petitioning for an amendment to the zoning regulations in order to forestall what she believed might be future efforts to circumvent the express prohibition against fast food restaurants in the CA80 zone. The record is devoid of any evidence that Calitro had any personal or financial interest in the proposed change, or that she harbored any animus towards the applicant who submitted the proposal. And the fact that the Zoning Commission approved the zone change at her behest does not operate to invalidate the legitimacy of its own ultimate legislative determination. A Zoning Commission is empowered to amend the zoning regulations even on its own motion, although the prescribed procedure for a referral to the City Plan and Zone Commission, Planning Commission and public hearings must be followed. So the takeaway from that decision, in my mind, is that the courts recognize the value that Director Calitro and other planning directors and planning department staff provide to zoning and planning commissions in carrying out your duties. And it establishes a presumption, which is well-founded, especially in Sharon's case, that the staff is acting properly and entirely professional when making recommendations or even in petitioning for zone changes and amendments. So it's a testament, the decision is a testament to the professionalism of the planning director and her staff. We're almost done. Next is testimony by experts. You'll often have experts come and testify to you on all kinds of things like traffic congestion, traffic safety, structural issues. The commission does not have to believe any witness, even an expert witness. But if it's technical matters that are beyond the purview of lay people, the commission cannot ignore the only expert evidence on a technical issue without putting on the record the basis for its disagreement with the expert and allowing the applicant and the public the opportunity to address those concerns. So if you're dealing with an expert and you don't agree with that expert for whatever reason, because you may have some expertise on your own, what you have to do is you have to go on the record and say, Mr. or Ms. So-and-so, I'm concerned about your conclusion, and let me tell you why. And that will give the expert and the public the opportunity to understand what your concerns are and address them. If you don't do that, if you intend to use your own expertise or knowledge of a site, you have to disclose that expertise or knowledge during the hearing, as well as the facts on which you're relying. And again, give the applicant and the public a chance to respond or rebut. Again, fundamental fairness. In certain matters, however, the commission can rely on its own knowledge and experience, including matters involving traffic, congestion, and traffic safety. The courts say that, Matt, you don't need to be an expert to know what traffic congestion is or what a traffic safety problem. Those are not considered technical issues. But again, the most prudent course is if you have experience with traffic congestion or traffic safety or other issues involving an application, put it on the record before the hearing closes, give the applicant the opportunity to rebut. That will insulate the decision, whichever way you go, from a challenge on that basis. Site visits. We've been through this most recently on the Danbury Career Academy, but they're authorized, they're appropriate. A site visit is not part of the public hearing, and thus compliance with the formal notice requirements for public hearings is not required. And agency members may vote on an application even though they have not attended a site inspection. But if you do a site inspection, the law requires that at the next hearing session after your visit, you have to disclose the fact that you visited the site and disclose the information that you obtained during the inspection. During the site visit, you should not ask questions about the substance of the application. You're not there to listen to questions or comments from the applicant or the public. Those are best addressed when you're at the public hearing. You're there to ask things like, where's this? What's this for? In other words, specific questions related to the site itself, not the issues in the application. And again, and I know you're aware of this, if there's a quorum of commissioners who plan to attend a site inspection, it should be noticed as a special meeting in order to avoid a charge that you conducted an illegal meeting of a public agency in violation of the Freedom of Information Act law. And again, in order to do that, in order to do a site inspection, of course, you always have to get the landowner's consent. And if the landowner refuses to allow the public to attend the site, let's say it says you can attend, commission members, but I'm not going to allow the members of the public to attend, that too could be deemed of an FOI violation, because any public meeting of a public agency, the public is required to attend. So if the landowner is not willing to allow the public to attend a meeting at which a site visit at which a quorum of the commission is going to be present, don't go forward with it. And the applicant will have to take his chances when you decide whether to grant the application. The right of members absent from a hearing to participate in the decision. You discussed that on the application tonight, Mr. Chairman. In order to vote and participate and vote on a petition or an application, a member or an alternate duly seated has to review the entire record, the documents, the exhibits, and the hearing tapes, the audio tapes or videotapes, and state that on the record when you're making the decision. Because if you don't do that, the court can reverse the decision on the grounds that the absent members did not fully familiarize themselves with the exhibits and the testimony. So again, protect the decision. If you're going to vote, make sure you put on the record that you listened to the tapes and you looked at all the exhibits and you're fully familiar with and ready to vote on the application. Alternates can participate in the public hearing, but if not seated for the decision, they should not participate in the decision process. And again, I've advised the commission, especially on controversial applications, that if you're an alternate and you're not seated, I would step down from the dais. I would not even be up on the dais, because you just don't want to give any impression to a potential appellant that somehow your presence on the dais, improperly contributed to the decision. Lastly, conflicts of interest and disqualification. You can't prejudge an application. Don't take a public position on an application or petition before the hearing on the application has been concluded. That doesn't mean that you can have no opinions whatsoever. You can express concerns to an applicant during the hearing, but what you want to do is avoid statements before or during the hearing suggesting that you've made up your mind. You know, you can certainly say something like, well, I have a concern about what if I voted for the application and I wanted to ask you a question about it, instead of, you know, I just really think this is a bad idea. That's the last thing you want to have on the hearing record. Years ago, I represented New Fairfield, the town, when they went to the New Fairfield Wetlands Commission and they wanted to get a wetlands permit to put a new septic system up at Meeting House Hill School. And a high-level official from DEEP came down, testified at the hearing before the Wetlands Commission that he thought that the system would adequately protect the wetlands and it had appropriate buffers, et cetera, et cetera. He stops his testimony and the chairman of the Inland Wetlands Commission says this: I find your testimony, Mr. So-and-so, to be arbitrary, capricious, and irrational. He says this during the hearing. And I'm sitting there as the applicant's counsel. I'm saying, wow, if this decision goes against me, guess what's going to be my first point on the appeal? That the chairman of the commission put on the record before the hearing was closed that he found the testimony of a high-ranking DEEP official capricious and arbitrary before the hearing even closed. That's probably an egregious example, but again, it's something to keep in mind. Avoid those kinds of comments that could be construed as prejudgment. No member of a planning commission or zoning commission or ZBA can appear for or represent any person in any matter pending before any of those agencies. And members of any other land use commissions cannot appear for or represent others before their own commissions. Just something to keep in mind. And no member of a land use commission may participate in a hearing or decision on any matter in which the member is directly or indirectly interested in a personal or financial sense. What is a personal sense? What is a financial sense? It's a very fact-intensive inquiry. But if if you're hostile to the applicant for whatever reason, if the applicant is your brother-in-law, those are obvious examples of when you just want to step down. And I always tell commission members that if there's any doubt about whether someone could accuse you, rightly or not, of having a personal or financial interest, get out. When in doubt, get out. Again, protect the integrity of decision. Don't create a needless ground for an appeal that otherwise would have no merit. Lastly, the decision itself. Obviously, as Attorney Edwards pointed out, you need to adhere to your standards and the criteria set forth in your regulations when deciding a particular petition or an application. You should, especially on controversial applications and technically on all applications, you should adopt a collective statement of reasons. In other words, it's not enough to just go around the room and say, well, what do you think? What do you think? What do you think? And then vote on it. There has to be a formal statement of the reasons adopted by the commission as a collective body in order for the court to look at that collective statement and say, okay, this is the reason why the commission decided this way. And again, just your own individual statement as a commissioner is not the same as the collective reasoning of the commission. So the better practice is get into the habit of stating your collective reasons. It focuses you and the commission as a whole on the evidence and on the standards and the regs. And what, as you know, you've utilized Director Calitro and our office in the past, especially on controversial applications, to prepare draft resolutions. Sometimes you'll ask us to prepare one resolution to approve, another resolution to deny, because you're still on the fence after you've had your first workshop session after the close of the public hearing. And that's very helpful because then you have an organized statement, and Sharon and Robin are just phenomenal in putting these resolutions together. And then you come back to the decision meeting and you look at the resolution draft, you read it into the record, and you consider it. You consider amendments to it, you consider deletions from it. But that way, at the end of the day, when you finally vote, you have a resolution. Again, you're protecting the record to present to the court as this is the collective statement of the entire commission. Final note, and my note here is just when you thought your training was over, there's part of Public Act 2129, Section 9 establishes, believe it or not, mandatory 4-hour training requirements for all local land use commission members. So starting in January of 2023, you need to conduct 4 hours of training in that year, and then every other year thereafter. What happens if you don't? I have no idea. But that's in their wisdom, that's what they decided they wanted you to do. And the training includes training on affordable and fair housing policies, Freedom of Information Act procedures, the conduct of public hearings and meetings, how to review site plans, surveys, and maps. What's the impact of zoning on the environment, agriculture, and historic resources? And OPM, the Office of Policy and Management, has developed training guidelines, which Director Calitro will be happy to provide to you, that kind of sets forth the particulars of the kind of training you need to get involved in. There's also a basic training course for zoning officials that's available from the UConn's Center for Land Use Education and Research Academy. It's called CLEAR. And you can go online, and they have very, very excellent guidelines on not only the issues we've just touched on tonight, but many, many more. So you should consider that as a resource, but we will be following up on implementing those new guidelines in the future. So with that, Mr. Chairman, that concludes our presentation. We'd be happy to entertain any questions, and Sharon Calitro may want to make a few comments herself, but on behalf of the director and Attorney Edwards, we want to thank you all for your dedication and your service to the city. Thank you.
Thank you very much, Attorney Casagrande, Attorney Edwards. You're like a fine wine, you get better every year, and we appreciate it. Thank you very much. Before I go on to the commission for asking any questions, Ms. Calitro, do you want to have anything to throw out there? You're on mute.
You're right, I was.
I got you.
No, thank you. No, I think it was a really good presentation, up to date on a lot of things. And as we know, and I've been coming forward to the commission with changes that are coming out of fast and furious out of Hartford, in order to, protect what we do in Danbury and keep it as local as we can. There's some things that we just don't have much control over. And I should say, I mean, it's changing daily. Things come out, extensions, new issues, and we'll just kind of keep you abreast of everything. As soon as we find out, you'll find out. So thank you to Attorney Edwards, Attorney Casagrande, of course, and all their good advice through the year. So thank you.
Thank you. Thank you very much. Commission members, I guess we're going to be getting a packet of this presentation shortly, email or, yeah, I guess email.
Yeah, well, I'll send you, Chairman, I'll send you a PDF of the presentation with, as well as the information that came out of OPM for the guidelines, which training for which would begin next year.
Now, is that information from OPM? Is that the actual specific curriculum, or are there courses, or is it suggestions of what we should be taught? I assume it's going to be by Corporation Counsel again, or what?
I'm not 100% sure. It's their land use training guidelines established in accordance with Section 9 of PA 2129 that became effective January 1st, 2022. And it gives you an overview and then tells you, what things, there's the mandatory training on, again, affordable and fair housing policy section, how to read the plans and things like that. And then some suggestions if you wanted to look at other areas, but it does kind of lay it out, I think, and maybe either even through WestCog, that they're may establish some kind of training sessions so that everybody can kind of utilize either the same organizations or the same opportunities to be trained, because this applies to ZBA, Planning Commission, and the Zoning Commission.
Thank you. Attorney Cassegrani, just on the side here, I'm just curious, has that Bethel case been heard by the Supreme Court and you're waiting a decision, or hasn't it been presented yet?
No, it's been briefed and I argued it in September.
Oh,
So we could be getting a decision any day now.
sure, absolutely. Wow. Well, good luck. Yeah, that's interesting. That's going to be a very, very interesting case, or decision, I should say. And I think you were kind to me on, I think, page 24 or so, when you talked about the commission that lost the case because they had neglected to read the Planning Commission recommendation in. I think the city of Danbury happened once, and I think the chairman was Haddad back about 38 years ago.
Yeah, I was there.
You were, I don't know how that happened.
I'm not here to throw you under the bus, Mr. Chair.
I know, you did great. Thank you. You could have very easily slipped it in there and I saw that it was missing. Thank you. Commission members.
Excuse me, Mr. Chairman.
Ms. Reed, yes.
I still have the stuff from our last training session, and the case law was there for ECB. So I can I can send that out when Sharon sends the other stuff out. If people want to read it, I still have it.
I think it's just not a tremendous pat on the back for Ms. Calitro, but it really, with the signal that it sends, is quite powerful. So yeah, if you could send that along as well.
Mhm.
Thank you very much.
Okay.
I read it and we did it last time, and I'll read it again because it's good reading. Commission members, any questions of Attorney Edwards, Attorney Cassegrani at this time? It doesn't look like we have, so I'm sure maybe if there's things that pop up after reading it over again once we get the packets. But in any event, excellent. We appreciate it. It's always very well received. Attorney Cassegrani, Attorney Edwards, really appreciate you and your dedication as well to the city, and Ms. Calitro as well also. And new Ms. Smith. I guess that's it. If no one else has any comments on this little workshop session. No. Okay. Thank you, Attorney Edwards, Attorney Cassegrani. Thank you, Commission. I think, Ms. Calitro, do we have anything else to go over tonight? Nothing else under for reference only?
No, I don't believe so. Do we have anything for the next meeting, Joanne? No.
No. Let me also call, I neglected, while we're on other matters, let me also ask, are there any other matters? Commission members, public, any other matters, any other matters, any other matters? No. Okay, back to that. No, I guess we have nothing else for the next meeting. So the next meeting is scheduled for April 12th, but when's the cutoff date on that? Or did it pass?
You're muted, Joe.
Oh, Joanne, there you go.
Well, yeah, it would have to, I think it would be Monday coming.
Monday, Friday, Monday.
Yeah.
Okay. All right.
I'm not looking at a calendar, but
If
yeah.
I don't have it by Monday, I can't get it to the News Times in time to advertise it twice before that meeting. So I would say Monday, the 28th. If I
Monday
don't
the
have anything,
28th.
I'll send out a cancellation notice,
Yep, perfect. All right, commission members. So we do have a meeting scheduled for April 12th, 2022, but as we just talked about, we may get a cancellation on that. And we'll look for that in our mailbox. I guess that's about it. I'd look for any other comments before I look for a motion to adjourn. Any other comments? No, thank you, everyone. Do I have a motion to adjourn? Motion to adjourn, anyone?
Mr. Coelho.
Mr. Coelho, I see you.
I'll make a motion to adjourn.
Motion by Ms. Coelho to adjourn. Is there a second?
Second.
Second by Commissioner Fay. Any discussion? All those in favor signify by saying aye. All those opposed, this public hearing is closed at, God bless you. This public hearing is closed at 9:09.
All right.
Okay, good night, everybody.
Thank you,
Have a
everyone.
great night. Thank you.
Thank you.
Thank you,
Good night.
everyone.